The legality of withholding funds, otherwise known as impoundment, from universities such as Harvard and Columbia. On February 14th of 2025, the U.S. Department of Education's Office for Civil Rights published a letter criticizing American higher institutions' embrace of pervasive and repugnant race-based preferences and other forms of racial discrimination. The letter cited to the Supreme Court's 2023 decision, Students for Fair Admissions versus Harvard, which held that the use of racial preferences in college admissions is generally unlawful. It also criticized DEI programs for stigmatizing students who belong to particular racial groups based on crude racial stereotypes, and thus denying students the ability to participate fully in the life of a school. The department made clear that it will no longer tolerate the overt and covert racial discrimination that has become widespread in this nation's educational institutions, and that institutions that fail to comply with federal civil rights laws may, consistent with applicable law, face potential loss of federal funding. The following month, the federal government announced cancellation of approximately $400 million in federal grants and contracts to Columbia University due to the school's continued inaction in the face of persistent harassment of Jewish students. Secretary of Education Linda McMahon stated, "Universities must comply with all federal anti-discrimination laws if they are going to receive federal funding. For too long, Columbia has abandoned that obligation to Jewish students studying on its campus. Today, we demonstrate to Columbia and other universities that we will not tolerate their appalling inaction any longer." In April, the Trump administration announced that it was freezing over $2 billion in grants to Harvard University over concerns regarding similar issues. President Trump also suggested that his administration would consider stripping Harvard of its tax-exempt status and be taxed as a political entity if it keeps pushing political, ideological, and terrorist-inspired or supporting sickness. Secretary McMahon has announced investigations of 45 universities for civil rights violations, and the Trump administration has already canceled roughly $11 billion worth of university research funding and grants, affecting over 24 universities. Some prominent schools, such as Columbia, Brown, and the University of Pennsylvania, have reached agreements with the Trump administration. Harvard University, however, filed a lawsuit against the Trump administration, arguing its freeze on research funding is unconstitutional and flatly unlawful. The lawsuit asserts that the First Amendment protects free speech against government interference intended to enforce ideological balance and bars the government from using legal sanctions or other coercion to suppress speech it doesn't like. The Constitution assigns Congress the authority over federal spending, while the President is responsible for implementing the spending decisions made by Congress. Article 1, Section 9, known as the Appropriations Clause, states, "No money shall be drawn from the Treasury but in consequence of appropriations made by law." This means that only Congress has the power to authorize the expenditure of federal funds. In contrast, Article 2 requires the President to take care that the laws be faithfully executed, which includes carrying out spending laws passed by Congress. Together, these provisions make clear that the President cannot spend money without congressional approval, nor can the President withhold funds that Congress has mandated to be spent unless legally authorized to do so. A congressional report from 1995 notes that presidents, at least since Thomas Jefferson, have asserted that the executive has some discretion in the expenditure of monies appropriated by Congress. This tug of war goes to the most basic tenet of the American democratic system of government, the balance of powers between the executive and the legislative branches of government, the power of the purse versus the impoundment power. The first significant impoundment of appropriated funds was made by the third president, Thomas Jefferson, who, in 1803, refused to spend $50,000 appropriated by Congress to provide gunboats to operate on the Mississippi River. Reflecting upon the changed circumstances following the Louisiana Purchase, he stated in his State of the Union address of 1803, "The favorable and peaceful turn of affairs on the Mississippi rendered an immediate execution of that law unnecessary. President Jefferson's decision was not challenged in the courts, and this set a precedent regarding the use of impoundment for economy and efficiency in government. Subsequently, President Madison announced to Congress in 1809 that he was reducing the crews of gunboats in New Orleans in order to save money that Congress had appropriated. President Ulysses S. Grant informed the House of Representatives in 1876 that, although he approved of an act providing appropriations for river and harbor projects, he did not intend to spend public monies on projects that served purely private or local interests as opposed to national interests. During World War I, President Woodrow Wilson declined to expend funds appropriated by Congress for holding a peace conference aimed at ending the war. President Hoover vigorously employed the impoundment power to decrease government spending in the midst of the Great Depression. In 1943, President Franklin D. Roosevelt informed Congress of his intent to restrict expenditures for certain civilian construction projects in order to focus on the war effort. In 1966, President Lyndon Johnson stated that, as a means of controlling inflation, his administration would withhold monies that Congress appropriated above the levels set forth in his administration's budget request. The balance of power shifted after President Richard Nixon was reelected in 1972. President Nixon attempted to ignore appropriations laws from the Democrat-dominated Congress, funding domestic spending programs that he opposed. After President Nixon decided to withhold appropriated funds designated for housing programs, disaster relief, and clean water, Congress passed the Congressional Budget and Impoundment Control Act of 1974, the ICA, which established a process by which presidents would need to request and receive permission from Congress in order to rescind appropriations. Under the law, after asking Congress to cancel an expenditure, a president can delay spending funds for up to 45 days when Congress is in session while awaiting a response, and both houses of Congress must agree to the cut or the administration has to spend the money. After the ICA was passed, the Supreme Court considered the impoundment question in Train versus City of New York. New York City sued the Nixon administration after Nixon withheld the money that Congress allocated to it under the Federal Water Pollution Control Act amendments. In a unanimous opinion from 1975, the Supreme Court held that the sole issue before us is whether the 1972 Act permits the administrator to allot to the states less than the entire amount authorized to be appropriated. We hold that the Act does not permit such action. Similarly, in 1998, the Supreme Court, in invalidating the Line Item Veto Act, reinforced the principle that the president cannot cancel or suspend parts of duly enacted laws. In Clinton versus City of New York, the majority held that the Constitution prohibits the president from canceling congressionally authorized spending because such an amendment must have been done by Congress. As one attorney explained, the Harvard funding freeze is essentially an exercise of unauthorized line item veto by the executive, selectively canceling budgetary line items granted to Harvard that Congress approved. Such action is unconstitutional under Clinton versus City of New York. President Trump has made clear that he believes the Impoundment Control Act is clearly unconstitutional, a blatant violation of the separation of powers, and he wants the Supreme Court to overturn it. On September 3rd, the U.S. District Court for the District of Massachusetts ruled in favor of Harvard, calling the Trump's freeze of money a targeted, ideologically motivated assault on this country's premier universities and amounted to retaliation, unconstitutional conditions, and unconstitutional coercion. In response, the Trump administration announced its plan to appeal the decision. According to the White House spokesperson Liz Hudson, to any fair-minded observer, it is clear that Harvard University failed to protect their students from harassment and allowed discrimination to plague their campus for years. Harvard does not have a constitutional right to taxpayer dollars and remains ineligible for grants in the future. The New Yorker published an opinion piece on September 6th of 2025 entitled Harvard's Mixed Victory, penned by a professor at Harvard Law School. The article suggests that, even following a resounding win for the university in court, the Trump administration is still left with plenty of ways to force schools into submission. Now that a case has vindicated the legal principles that Harvard has been asserting on behalf of universities, the question is whether it will make a practical difference. Even while rejecting many of the administration's demands, Harvard has in recent months made moves that share something of the flavor of the administration's preferences. Beyond addressing anti Semitism, the university has been reviewing admissions, appointments, curriculum, and orientation and training programs. It is considering starting a Center for Conservative Scholarship. Multiple Harvard schools have ended or rebranded DEI offices. Harvard's athletics website has scrubbed from its pages a policy pledging inclusion for transgender athletes. Harvard's public health school has suspended a partnership with a West Bank university. Hence, while it seems unlikely that the Supreme Court would declare the Impoundment Control Act unconstitutional, Trump may nevertheless emerge victorious in reshaping the culture on college campuses.